Qiyas or analogy is a source of Islamic law for the Sunni schools. Those who did not accept Qiyas as a source were excluded from the Sunni fold. The best example is that of the Zahiri school, which was excluded and later became extinct. The net impact of such exclusion is that the opinions of this school are not binding on the Sunnis and are not to be followed by them, even though there were certain well-known scholars in this school. In its literal meaning, the word qiyas means measuring or estimating one thing in terms of another. Thus, measuring cloth against the meter rod is qiyas. It also applies to making two things equal, that is, comparing. This comparison may be physical or it may be rational. Thus, mapping a shoe upon a shoe to see their equality is qiyas. The word qiyas is sometimes used in its figurative sense and not its actual sense to mean examination or even ijtihad, which is its method by the application of the term used for the cause to the resulting activity. The distinction between these terms needs to be maintained to avoid confusion. In the technical sense, as defined by the jurists, it applies to the assignment of the legal rule of an existing case found in the texts of the Quran, the Sunnah, or consensus to a new case whose legal rule is not found in these sources on the basis of a common underlying attribute called the Illah of the legal rule. Another definition is the equality of a case whose legal rule is not mentioned explicitly in the text with a case whose legal rule is mentioned on the basis of the equality between the underlying causes found in the two cases. If the texts of the Quran or the Sunnah or consensus contain a case whose underlying cause is known to the jurist, because of which the legal rule has been laid down, and he then sees a new case which has the same underlying cause in it, he will assign the legal rule of the existing case to the new case. By such an assignment, he renders the two cases equal in terms of the legal rule. This assignment or rendering equal is called qiyas in the terminology of the jurists. A few examples will help in understanding the operation of qiyas. First example, the prohibition of wine from grapes is laid down in the Quran. The text prohibits wine along with a statement of the disaster it leads to, that is, enmity and hatred among people. Now, khamr, according to the Hanafi jurists, is the name of an intoxicating liquor made from grape juice, called wine in English. The Arabic term khamr, in their view, does not include other intoxicating liquors like whiskey and beer that are made from other substances. The other intoxicants, according to the Hanafis, are prohibited separately by the texts of the Sunnah. The Hanafis, therefore, see no need to use analogy in this case. The majority, however, say that even if the word khamr, in its literal meaning, does not cover the other types of intoxicating liquors, the legal rule of khamr can be extended to them through qiyas. Their reasoning takes the following form. The jurists first decide that the underlying cause for which khamr has been prohibited is intoxication. On examining the other intoxicating liquors, they find that the property of being intoxicants is found in them. When it is verified that this property is found, they extend the hukam of khamr, which is prohibition, to the other intoxicating liquors as well. Second example, there is a tradition from the Prophet, peace be upon him, that says, the murderer will not inherit. This tradition prohibits the granting of inheritance to an heir who kills his predecessor from whom he is to inherit. The punishment for such an offender, in addition to the punishment for his crime, is deprivation of inheritance. What about a bequest? The tradition mentions inheritance alone and not bequest. Supposing a legatee murders the testator who has bequeathed his property to the legatee in his will, the offending legatee will be prevented from taking the bequeathed property on the basis of qiyas, because the underlying cause in the two cases is similar, which is hastening the benefit prior to its appointed time through a criminal act or unjustified enrichment. Third example, a tradition from the Prophet, peace be upon him, says, a believer is a brother to his believer, Therefore, it is not permitted for a believer to make a proposal for marriage, where the proposal of his brother is still pending, or to make an offer of sale where his brother's offer is pending. This tradition prescribes proposals or offers to the same party till such time that similar offers made to this party by another person are pending and have not been refused or accepted. The underlying cause is the causing of harm to another's interest. This tradition does not mention the hiring of services or property. The prescription can be extended to hire through analogy. Fourth example, indulging in sale when the call for the Friday prayer is made is prohibited by the text of the Quran. The underlying cause is reducing the incentive to offer the Friday prayer. This legal rule can be extended to other contracts like pledging or marriage that may have been planned at such a time,